Welcome to the Self-Wealth Real Estate Podcast, Episode 4 with my guest, Marc Soscia. Today, we got to talk to an experienced real estate lawyer. I actually got to go to law school and do my MBA with Marc. He graduated a year before me. He's an expert. He works on a lot of my transactions. He's done probably hundreds of transactions for me at this point. Today, we get into some of the common things that happen with wholesaling, some contract issues, things that might come up. As you know, I like to make this podcast very deal-focused or situational-focused. Real-life examples really help us understand what you can expect and help you learn from those situations. So Marc talks about, situations that have gone wrong, what to look for in the contracts you're doing. Listening to this podcast will help prep you to prepare your own contracts, make sure you're doing things right. This also works for more experienced investors. And he does talk a little bit about corporate structuring and things like that as well. So I'm really happy we had Marc on. And thank you so much for listening once again. Take care. Welcome to the Self-Wealth Real Estate Podcast with your host, Luke Boyaron. Today, we are talking to Marc Soscia. Marc is a friend of mine. We actually knew each other in law school. We went to law school together and MBA together, kind of, because you finished before me, right, Marc?
1 year before you.
Yes. So Marc, tell us a little bit about yourself. What do you do now, and how have you gotten to where you are?
Oh, well, first of all, thanks for that great introduction, Luke, and congratulations on your new platform. I think you have a lot of knowledge to share, and I think that there are a lot of people out there who can really benefit from the conversations you're having with various people, and thank you very much for having me on. A little bit about me. So, like you, I did the JD MBA at Schulich and Osgood. I thought I wanted to be a downtown corporate lawyer, and I was for a few years, and that was long enough for me to know that the lifestyle wasn't for me. I didn't want to move in-house, and I didn't want to be a partner at a large law firm. So after the hire back process and being asked to come back as an associate after the articling process at my firm, it took about little under a year for me to decide that I didn't want to stick around there and I wanted to do something a little bit more entrepreneurial. So I left the downtown life, started up my own practice, first with an office in Mississauga, and then moved to Vaughan about 4 years ago, partnered up with another former Bay Street lawyer at the same firm who used to practice at the same firm. We formed my current firm, By Marc Law LLP, and we've been practicing in Vaughan for the last 5 years or so. My goal is to sort of be able to help small business owners, medium-sized business owners, real estate investors handle most aspects of what they need. So my practice includes real estate law, obviously. It also includes corporate law because I have a background in that, and it includes estates. So what I find is I have a lot of clients who are small or medium-sized business owners. They operate their business, and their favorite thing to invest in outside their business is real estate. So I'm able to help them with their corporate work. I'm able to help them with their real estate work. And then as a value add, I'm able to, I know so much about their life and their business and their family and their real estate holdings that it only makes sense that I can also give them some estate advice. And I'm able to offer that component as well. So that's the scope of my practice. It doesn't go beyond that. And then for specialist matters, I have a wide network of litigators and tax lawyers and things like that who I can refer, family lawyers who I can refer people who, in my client base who need work, but who need work outside the scope of what I can do, because I'm able to keep pretty busy doing those three things, and that's what I enjoy, so that's what I focus on.
Nice. And what would you say, kind of what's the largest area of practice that you do? Or what are what's the split?
I would say... Good question. I see probably 50% real estate, and real estate is subdivided into, I do some residential real estate, I do some assignment transactions where I act for wholesalers, and then I also do a few larger commercial transactions, whether it be acquisition of commercial buildings or vacant land that's intended for development. So that's the real estate portion of it. Then I'd say probably half real estate, 40% corporate, 10% estates. And then within the commercial aspect of it, the commercial aspect of my practice often involves it often overlaps a fair bit with the corporate aspect. The reason being is because if you have, in often cases, if you're buying a 40 or 50 million or helping your clients buy a 40 or 50 million dollar piece of land, it'll be the case where multiple investors are pooling assets. So you have to help them with a corporate structure in conjunction with their tax advisors that makes sense from a tax perspective, and it deals with the usual kind of problems that people can run into when they make joint investments. Like one guy wants his money out, one guy doesn't. One guy wants to refinance, another guy doesn't. So we need a mechanism to pool capital and be able to use it to acquire these assets. And oftentimes that's incorporation of a simple corporation. Sometimes it's formation of a general partnership, or a limited partnership rather. So there are a number of structures that I do. So oftentimes, like, there's always kind of cross-pollination between the different areas of my practices.
Awesome. And yeah, obviously for the audience, Marc closes a lot of our assignment deals and some of our long-term holds or other flip purchases. So, it's real estate closings, and it's also like closings of purchases and sales of real property, as well as assignments of them that you and another lawyer work on.
We're happy to be. We've been working together for a few years, and I enjoy it. Love working with the team. It's great people.
Yeah, because you probably closed, I don't know, 100, 200 more
easily.
Yeah, more.
Yeah. It's been several years. So yeah,
hundreds.
You're a busy guy. I'm a busy guy, and we're certainly busy together. So it's good.
Yeah,
busy is good. Iron sharpens iron. Yeah,
exactly. So a few things I want to talk about is, let's start with the wholesaling or closing assignments. Particularly in this case, we're talking about, let me ask, do you close a lot of, the typical Toronto assignments, which are, new construction condos, new construction homes, and you're closing those for the, for the buyer seller?
I do. I close them a handful of times. Sometimes I'll be doing them on the assignor side. Sometimes I'll be doing them on the assignee side. Sometimes I'll even be doing them on the vendor side if I'm doing, I have a handful of subdivisions or things like that I'm working on. My partner also does that kind of work too. So yeah, I've worked on all various facets. And as you said, most people who aren't in the business of wholesaling, the only time they might touch an assignment is if they've purchased a new build property, either a condo or a freehold property. There's been a change in their circumstances, and they want to dispose of that property before the closing date, right? So I've had that happen before. I've also represented buyers who have purchased new build property by way of an assignment, so that on the closing date, they pay the vendor, and then they also pay the original purchaser for the delta in the purchase price between the assignment price on the one hand and the price due to the builder on the other hand. And in that process there, it's generally the builder that calls the shots, because and this is important for everybody to know, the common law is permissive of assignment absent a restriction to the contrary in the contract. So what does that mean in plain English? What that means in plain English is that any contract that you as a buyer sign, you have a right of assignment at common law. You can assign your benefits to somebody else as long as the contract does not expressly say that this cannot be assigned. So those builder agreements, the builder wants to hold all the cards, and those builder agreements, all those builder agreements will contain an express restriction on assignment. The OREA form documents, we have to remember who is drafting these documents, right? And when the builder holds the pen, the builder drafts it to advance their interests and wants to see deals closed, but wants to give themselves flexibility and things like that in connection with the deal. When we use the OREA forms, who's drafting the forms? It's the realtors, right? And the realtors want to give themselves the flexibility to advance their interests and do further transactions, and advance the interests of their clients and give their clients flexibility when they sign these documents. So the standard OREA purchase agreement, if you take a Form 100 for purchase freehold property, there's no restriction on assignment in there, which means that anybody that buys property via OREA Form 100 can assign that contract to another purchaser. So oftentimes when I'm acting on an assignment deal for the assignor, the person who holds the property and wants to further sell it to somebody else, flip it to somebody else before closing, let's call it. Oftentimes I will notify the vendor's lawyer. It happens maybe 10 or 5% of the time, I'll notify the vendor's lawyer. I'll say, I represent the purchaser. The purchaser has assigned its rights under the contract to to a subsequent purchaser. Please deal with the purchaser's lawyer. In some cases, my wholesaling clients will not have an express assignment clause in there saying that the buyer has the right to assign this agreement at any time upon notice, and upon transmission of such notice will be relieved of all liability hereunder. Some of my clients don't like to put that in the document because it kind of tips their hand as to what they're trying to do, and they think it'll make it harder for them to find a buyer or find sellers, right? So when I run into situations like that where the seller's lawyer will come back to me and say, Mark, there's no express right of assignment in here, I have to go back to them and I say, well, you know what? The common law is permissive of assignment, absent a restriction to the contrary in the contract itself. My clients are assigning their rights, but they're not assigning their liabilities. If the subsequent purchaser doesn't close, you have access to the deposit as a guarantee of performance. You have you can sue my client for a breach of contract because they failed to tender as well. But you have to convey title to the purchaser, and you have to deal with the subsequent purchaser. And they squawk, for about 3 or 4 emails. And what I've done now, I run into this so frequently, is there's a series of books that anybody that's got to law school should know called the Irwin Law Books. And that, these, Luke, you remember these, studying late night in the Osgood Library, trying to put together a summary, right? And they do a really good job of laying out the law very simply. It's like law for dummies, these Irwin Law Books, right? Or at least law for law students, right? So not for lawyers. So what I have now that I send out is I have a page from the Irwin Law Book that sets out the common law position on assignment. And whenever somebody says to me, your client can't assign this, and I see there's no restriction on assignment in the contract, I just send them a photocopy with the cover page of the book, Wadham's on Contracts, a page of the applicable discussion on assignment, and that keeps them quiet pretty quickly. So I've got, and what you'll find if you practice and you do a lot of transactions, you tend to run into the same 4 or 5 problems that people argue about. And literally what I have now, because you can go back and forth, lawyers can be we're very, very stubborn as a profession, obviously, right? So if anything you can have that can kind of cut a conversation before the 50th email is great. So I've got all these printouts from Irwin Law saying the various standard positions on common issues that I have, and instead of engaging in an email exchange, just here's Wadham's on Contracts, and you could talk to Wadham if you have questions.
I feel like half the people who go to law school just have been told growing up, oh, you're so argumentative, you should become a lawyer. And they're like, yeah, I should. I'm good at arguing. They go to law school and they just like arguing with people. So yeah, you have some lawyers who just like arguing.
Oh yeah.
And it's funny how you modify what you do based on, like you said, these repeat things that happen. For us, that's one of the reasons we always put in the clause in our assignment agreement, in our purchase contract, that we can assign it, because then we've run into that where the other side's lawyer says, no, you can't assign it. It's not a contract. Well, and then we're arguing, well, common law in Ontario does allow this. And so it's an argument, and we're like, well, let's take that step out of it. Let's not risk the argument, because it's not just the lawyer talking to the lawyer. Sometimes the lawyer then tells their client, well, no, what they're doing is illegal, it's not allowed, and it starts making us look bad. So we always put a clause in that says we're allowed to assign it, and that it relieves us of liability. Typically, we keep that clause in, because like you said, you're not relieved of liability if you don't have that. So, that's a risk we don't necessarily want to take on most of our deals. They can be negotiated out, but yeah.
Very well put, because what you said is, and this is the view I always take, when you're drafting a legal document, you have to think of it as a document that allocates and deals with business risks, right? So you are thinking about when you determine you want to put the clause in that says that the purchaser has an express right of assignment and is relieved of liability, you're weighing 2 competing ideas in your head. On one hand, you want to be able to sign this deal so that you can assign it. On the other hand, you want to think, what's going to make the process of completing the assignment after with minimal liability, what's going to make that easier? So you've got 2 things tugging you in different directions, and you've obviously made a business decision that it makes more sense for you to deal with the issue of explaining to the seller what the assignment clause means and why it might be there than it is to deal with the seller's lawyer after to try to argue that the assignment is valid and to relieve yourself of liability, right? So everybody, when you're putting, and I think a lot of lawyers don't understand this, they think we're kind of drafting these documents that can be derived from like Platonic ideals that just come down from the ether and there's this perfect document. There really is no perfect document. It really depends on your client's level of risk, the risks he's willing to accept, the risks he's not willing to accept, and realizing that risk is like a seesaw, that to minimize one risk, you might exacerbate another risk, right? And that's something that you really have to be attuned to, because a lot of lawyers is, this is my precedent, this is my practice, and that's meant to shut down the client and what they want, right? You have to take, when you're advising real estate investors, when you're advising small businessmen, you really need to take a client-centered approach. At least me, my practice, you need to take a client-centered approach and a client-focused approach. And really, I give the advice. I don't make the decisions, right? And I think that sort of hit the nail on the head. Is this is a business document that we're drafting at the end of the day, as much as it is a legal document. It has to strike the right balance between risk and reward for you, right?
Have you ever watched the TV show Suits?
I watched the first season or two. The first season after Meghan Markle was gone, no, I'm joking. I don't even know when she was gone, but yeah, I watched it first season. I watched actually when we were in law school.
Yes, I think so too. I watched the first couple seasons and I kind of got bored of it. But one of the things, it's interesting, and it kind of goes to what you're saying, is in that TV show, you know, I don't even remember the main character, but the main character, you know, he'd have some legal issue, they'd be losing a case, and then he'd go kind of sit in the library all night, or he'd like remember something from his photographic memory, find a solution and be able to win every case. And that's not the way law works. You're trying to get the best possible result with the fact pattern you have, but it's first of all, you never know for sure. There's always risks, and that's why, you know, you might consider settling a case even though you're very strong, even if you're certain you're going to win. For one, there's sometimes technicalities that things get thrown out on, and even if you don't think that's going to happen, it's the time and the cost of going through, let's say, a lawsuit. You know, that it takes a lot of time, so you might consider settling to avoid that risk and avoid the costs that there are. But it also is just, sometimes you're like, well, I'm probably going to lose. How do I minimize my loss? Or I'm probably going to win, but how do I increase the odds that I win? But it's just, it's never like it is in the TV show where you just go and you're like, oh, I found the perfect answer and now I won. And because of that, it's never like, well, if only my lawyer had spent more time in the library or something, that they would just find a way for me to win. It doesn't work like that. With everything in life, I look at it as, you know, what gives me the best odds of the best result. Mm-hmm. That's what I'm looking to do. And my decisions should give me the best odds. But there's no perfect decision, and there's no perfect way to do everything. Same thing, there's no perfect contract, and it may work better with one seller or one legal situation, but then it didn't work so well with the other one. And so be it. You're playing what's going to give you the best odds on average.
You always have to take a pragmatic approach. You have to consider the likelihood of unintended consequences if you choose a course of action, that it's likely to produce results that you may not intend or may not desire. And you've got to take that into your risk analysis. And yeah, you're right. Life is not TV, and law is definitely not like TV. I mean, I look nothing like Harvey Specter. I wish I did, but I don't have Harvey's good looks. I don't have Mike's brain. And
you're a good looking guy. Come on.
Right?
All right. So, well, speaking of all of that, in terms of closing wholesale assignment deals specifically, what are some best practices you see, kind of both that, you know, could be in the contracts, but also in terms of what the lawyer should do to increase the odds that the deals go through? What are some best practices you guys deal with?
Best practices are, I think that a lot of it happens out. So you're talking about from the purchaser side or from the wholesaler lawyer side?
From the wholesaler's lawyer side.
Well, so from my perspective, if I'm doing an assignment transaction for the assignor, and that's for the benefit of the viewers, that's the party who signs the agreement of purchase and sale and then wants to quote unquote flip or assign the contract before the closing and make a fee on the spread, right?
Yeah.
So if I'm acting for an assignor, I mean, there's certain things that are out of your control in the sense that, like, is the purchaser going to have the financing? Is the purchaser's lawyer going to act accordingly? Really, what you can do, your job is to kind of quarterback the transaction And the first thing that you want to do is give notice to the vendor's lawyer prior to the requisition date. So every OREA agreement of person sale, Section 10, residential Section 10, I don't recall where it is in commercial. Section 10 will say that there's a title search date. And that's the date by which the buyer's lawyer has to deliver a list of requests with respect to title to say, these are things, hey, vendor, these are things you have to fix with title to the property before we'll close. And that will be like, we want a mortgage, certain mortgages deleted, certain rights that have expired need to be deleted on property. Maybe there's a construction lien, certificate of pending litigation. So that's a pretty important date. And what you want to do is you want to give the vendor's lawyer notice of the assignment before that date, so that when they receive requisitions from the buyer's lawyer, they're not taken aback and saying, "Hey, why am I receiving requisitions from Stiver Valley when I should be receiving requisitions from Bymark Law because it says Bymark Law is representing the purchaser," for example. So that's the first thing you want to do. It also you want to give yourself enough time that if the seller's lawyer squawks about assignment, that you have time to go back and forth with them and send them that Waterhouse document and maybe have a call with them, right, to pacify them. So that's the first thing, is you want to give notice to the vendor's lawyer to make sure that they understand their position in the transaction and the assignee's position in the transaction. The other thing that the seller's lawyer will sometimes ask for is they'll ask for a copy of the assignment agreement. And oftentimes the assignment agreement will say that it's confidential as between the purchaser and between the assignor and the assignee. In cases where the vendor's lawyer asks for a copy of the assignment agreement, I'm sympathetic to that. I get why they would want that and why they wouldn't want to rely on notice. So my practice is usually to redact the important financial parts of the spicier parts of the contract, right, of the assignment agreement, which say how much profit the wholesaler is making, and send that to them. Because really what they're looking for is they're looking for a paper trail that they can show if they end up being if it ends up being alleged that title was directed to the wrong property, title to the property was directed to the wrong buyer. They want a paper trail showing why they transferred to the assignee and not the assignor. So I would have the assignment agreement ready, redacted. I would send out notice before the requisition date. That's going to leave you plenty of time to deal with objections to the assignment. The other thing that I would do is plenty of time before closing, I would give the assignee's lawyer a statement of adjustments. This way they understand the funds flow on the transaction, because assignment agreements can get very confusing, especially dealing in certain cases with the deposit that's paid under the agreement of purchase and sale. Who's holding the deposit? How does the deposit factor into the payments that are going to occur between the ultimate purchaser and the vendor? How does the deposit factor into the payments between the assignor and the assignee? So if when you send this notice, my general practice is before the requisition date, give them notice, give yourself plenty of time to deal with objections to the assignment from the vendor, and give the purchaser's lawyer plenty of time to understand how much they're going to have to pay the assignee, the assignor on the closing. They're going to have to pay to my office on the closing. So I'll give them a statement of adjustments, right? Very early. Then the other thing is on the transaction date, just first email in the morning whenever I have an assignment deal closing is, just reply all and email to the, usually I deal with the assignee's lawyer on the closing day. I don't really deal with the vendor's lawyer anymore. Say, hey, everything in order to close on the purchase and assignment, for ease of reference, here's the statement of adjustments and here are my trust account particulars. Just want to make sure that everything's going to be ready to close today, right? And if I don't hear from them by noon, follow up with them by noon. If I don't hear from them by 4 p.m., phone calls start, right? And that's really what you could do to shepherd and quarterback the transaction as the assignor's lawyer, is basically make sure you provide notice and make sure you provide it with enough time that you can deal with objections to the assignment by the vendor, and make sure that you provide the purchaser with funds flow soon so they can work out the mechanics on their end. Because the other thing is, a lot of assignees lawyers, you might think, okay, it's the vendor's lawyer who's going to have objections to the assignment. A lot of cases, and lawyers haven't closed, purchasers' lawyers haven't closed deals by way of assignment except from a builder, which is a very different kind of transaction. So they might have objections. So it's just about starting early and giving notice and then staying on top of things on the closing day. But having said that, there are always things that can go wrong. Maybe the buyer doesn't have his financing in order and they don't tell you. These things happen, and that's just part of the business risk, right? Like you said, there's no perfect transaction, and there are certain risks that your lawyer can merely advise you of, but can't do anything to minimize, right? Like I always tell my client, if money's owed to my office, whether it's by way of a sale or assignment, oh, Mark, why didn't we close? Well, what did you want me to do? Did you want me to go to the buyer's lawyer's office with a pistol and demand the funds? Like, if they don't have the money, they don't have the money, right? So there are certain risks that we can't minimize and that we just have to accept as being innate to the process and the business that we've chosen to deal in. But yeah, that's what I would say about minimizing risk on assignment transactions.
Nice. One thing I wanted to ask is title search date. What's your opinion on, how far before closing or when should title search date be?
Good question. I mean, I say generally about 2 weeks before closing. So the title search date, basically what you want is it to occur a long enough period before closing that if there really are any serious issues with title, that the vendor's lawyer has enough time to rectify them. So I think 2 weeks gives most lawyers who are on the ball the ability to rectify most the title issues. Some exceptions might be if there's like if there's a right on title, which is clearly expired and no longer relevant, but can't be deleted because we can't get in contact with the person who has the right. So one example I've seen is old mortgages registered on title. So this happened with a family member of mine that they paid out their mortgage in like 1995, right? And I did a refinance for them. They got like a secured line of credit in 2016, right? And I did a title search, and this family member had said for years and years and years, oh yeah, my mortgage is paid off, my mortgage is paid off, my mortgage is paid off. I do my title search on a refinance, and I find out, oh, there's a mortgage to their financial institution that was supposedly paid off. And it took, in this case here, it was a unique situation, but sometimes it can take weeks to have those mortgages discharged. So I would say give it at least 2 weeks. You don't want to do it too far out. And the reason why you don't want to do it too far out is because if you do it months, and if you say you have a really long closing, then there's always the risk that there could be intervening registrations between your title search date and your closing date, which will not be caught until the closing date, because your lawyer, what he'll do is he'll do a title search on the search date. He'll tell the vendor's lawyer what needs to be fixed on title. And then before closing, he'll do a sub-search to make, on closing rather, like literally the moment before registering the transfer to transfer title to the purchaser, is he will do a sub-search to make sure that there have been no intervening registrations between the title search date and the actual closing date. So the longer the gap between the title search date and the closing date, the more likely there's going to be an intervening registration or registered. But I think that it's very, very rare that you get an intervening registration. And we talked about being pragmatic a minute ago. I would err on the side of having a little bit of a longer period between the requisition date and the closing date to give the vendor's lawyer more time to deal with something on title that needs to be dealt with, because I think that risk is much greater than the risk of an intervening registration. So I would say minimum 10 days, 2 or 3 weeks is probably better.
Yeah. I remember we've had a few of those old mortgages stay on our deal.
Well, sometimes you got into something like
1975 that had been paid off in the 80s, and it was still on title. But it was like a private mortgage, and
it was a private mortgage. Private
mortgage might have been dead. We had no idea. Yeah.
I've had mortgages with old banks, like banks that no longer exist, trust companies that no longer exist. It's like, and I've even had, and the other thing is like, that there are some issues with title that can take months and months to fix. I'm dealing with an instance right now where I have a client, thank goodness they're not selling the property anytime soon, but I sat down with the client and I was doing their, I was doing an estate plan for them. I was doing their wills, and they mentioned that they held property in the name of a corporation. So I did a title search on the property, and I say, okay, great. This is the name of the corporation, ABC Co. And then I did a corporate search on the name ABC Co. And it turns out ABC Co. doesn't exist. And I said, whoa, this is a problem, because if a corporation is dissolved while it owns real property, the property reverts to the crown. It reverts to the government. It goes to the government title to the property by operation of law. It's called a cheat to the crown. You would remember this, of course, from law school, right? Wake up having nightmares about this kind of thing, right? So I get really scared, and I say, listen, this company that owns the land doesn't exist. Can you give me something with the corporate name on it? Like, of course, they don't have a minute book. It's an old corporation. Is there anything to say, oh, okay, I can maybe try to dig up articles of incorporation or something? They can't find anything. So I'm frantically searching the business registry for names that are similar to this corporation name. And I find one, and I pull a corporate profile report for a corporation with a similar name. So on title, it's ABC Co. I look for, ABCD Co., right? And I find ABCD Co., and I find that it's my client who is the registered officer and director of ABCD Co. And I say, well, you're holding title in the name of a corporation that doesn't exist. And I say, I don't know how we fix this. We can't register a name change because the corporation never had this name, right? So it's not, the corporation's name was never changed. It was registered in the wrong name. And now we've had to get a litigator to go to the court, and he's going to lead evidence to say, listen, this was an error. The lawyer on registration, didn't ascertain the proper legal name of the corporation. ABC Co. has been paying all the taxes, and they've been acting like they're the owner of the property. Can we please get a court order restoring title to ABC Co.? And the same corporation, very, very, so that's an example of title. Like, even 3 weeks is not going to be enough for that, right?
I could go down a rabbit hole here. Actually, so what was it? What would happen if it was like an individual? Let's say someone spelled my name wrong. Instead of registering it under Luc Boiron, they registered under Bouk Boiron.
So in that, good question. In that case, if it was like a legitimate error in the name of a natural person, I think you could. And I've dealt with that before. I mean, I've seen that where I've acted for a vendor, and actually happened very recently in my office where the vendor had the wrong name on title, like it wasn't the legal name, or there was a little bit of an error, there was a letter missing or something. In that case, what I did was I just said that so and so like is one and the same person. If it's like a missing letter, if it's a name that's completely off. You might be able to register a name change in the case of an actual person for something that's clearly manifesting like a clerical error. I think that I've remedied that in the natural person context before, but not in the business context. I don't think that it would work, because when you change a name for a corporation on title, you're more restricted in what you can do in terms of the boxes you can tick on the amending document or the name change document. So it can be scary. You got to be careful. You got to dot all your I's and cross all your T's. And that's why we as lawyers, we take a lot of risk that I think some people don't understand, that, a typo that wouldn't have an effect on anybody else's business, if you're, it can affect you as a lawyer. Like, I'll give you another horror story. I have clients, I help them sell an apartment building, multi-million, we're talking like over $20, $30 million apartment building, very valuable apartment building. They gave me the agreement of purchase and sale to review before it was signed. So I was acting for the vendor, and I just want to check and make sure that the legal description is okay. So I check, and I see, okay, the legal description is great, but my client doesn't own this. Mr. Smith owns this, right? Like, it was a natural person that owns this. Mm-hmm. I went back to my clients and I said, guys, what happened here? This is the owner here. And they said, oh my goodness. They said, we transferred a separate property that was touching the apartment building. We transferred this separate property to Mr. Smith like 15 years ago. And I said, well, when your lawyer transferred the small property, he also transferred the apartment building to Mr. Smith. So you have Mr. Smith is the titled owner to this apartment building. You don't own this $20 million, but whatever, $20, $30 million apartment building, right? So very, very scary. In that situation, and good thing I caught it because oftentimes like the agreement of purchase and sale doesn't come to the lawyer before it's signed. Like this one here, I said, you got to wait, we got to fix this. Like we got to figure this out before you sign any agreement to sell this, right? And we were actually able to get a hold of, in this case, Mr. Smith, and we were able to have him retain a lawyer, and I corresponded with his lawyer and said, listen, this is what happened. Really, it's a constructive trust relationship where Mr. Smith, even though he was the registered owner of the property, it was done by error. My clients have maintained possession and been paying, and they act like the owner. So let's avoid litigation, and can we just acknowledge that this has been a constructive trust for all these years? Constructive trust is basically a way of saying that even though there was no formal trust document, that Mr. Smith in this case was deemed to have held the property in trust for my client. And we were able to get Mr. Smith to, sign a declaration of trust acknowledging the error and transfer property to the restore title to the property to my client. And if Mr. Smith had been dead, that would have been a lot. And so what happened? So why did this error make a mistake? Why did this error occur? Basically, what happened was when my client acquired this property, they acquired the valuable apartment building and the little piece of land next to the apartment building by way of the same deed, right? And when probably the clerk, I would imagine, for my client's old lawyer, acted to transfer the little piece of land, she just looked at what properties were transferred on the old deed. Okay, that's what's being transferred now. And she inadvertently transferred property that was, she inadvertently transferred a very valuable property in error to people who hadn't paid for it, right? And that's the kind of risk that we as lawyers take, right? That's why you have to be diligent. And real estate, I think that a lot of people now, real estate law has become something of a race to the bottom in terms of fees. It's seen as a cookie cutter commodity, I think. And you have people sort of competing race to the bottom, right? Like when I get people call me and their first question is, what are your fees? I say my fees are not the cheapest. If you're looking for the cheapest, you could probably go somewhere else. So if you're just competing based on price, if your sole determinant is price and you want to see that I'm going to be the least expensive quote that you get, I'm not even going to give you a quote. If you want somebody like I picked up my phone, I'm talking to you, right? I'm talking to you in generality about your transaction and talking to you in generality about the way real estate transactions work, and you haven't even retained me yet, right? So if you want that kind of relationship with your lawyer, then I'll give you a quote and you can determine if you think there's value. But if you're just looking for the least expensive guy in the street, I'm not the least expensive guy in the street, and I don't desire to be, right? So people have to take into account the fact that when law is practiced fast and high volume and cookie cutter, quality suffers. And this is something where this is a service where you don't want quality to suffer. You want somebody who is able to parachute in on your transaction and save it and devote 2 or 3 hours on the closing day if he needs to close your transaction and make it happen. You don't want somebody who thinks of everything as just volume and give it all to a clerk. And I still meet with all my clients personally for all my transactions. I have a personal call with all my clients before I take them on. It's not a matter of when somebody needs legal services that they're just passed off to a clerk or a support. Even though my clerk is fantastic and she's great, she's very competent. There are certain things that support staff shouldn't be doing, and certainly roles that a certain hand that the lawyer should play in the transaction, right? And I think that's very important. So that's the way I run my practice. And wow, how did we get there? This all started with how soon should you? What's the proper length of time between the requisition date and the closing date? And we've all of a sudden got here. So that's the beauty of a podcast, right? Is I think we had like 6 or 7 questions that we thought about we might want to ask. We've gone through maybe 2. Your biggest question was asking me to talk a little bit about myself at the beginning, because given that opportunity, I think I took like 10 minutes.
No, that's great. Actually, one of the things I do typically when interviewing real estate investors is part of the show is I like talking about our best and worst deals that people have done, because I think people learn the most from those examples. Instead, I'd love to hear just a few common issues that you see. And in a couple different ways, because I think, again, those will be good examples for people to learn from. Like you said, a lot of the time your clients are coming to you after they have a signed agreement that you haven't discussed with them. So I'd love to see two parts. One is common issues that you see when people bring you an already signed contract and mistakes in there that you then have to rectify. That's one. And then two is just other common issues that regularly come up with deals, and maybe if they can be dealt with or how they can be dealt with or just what to expect. Common issues that come up with just regular residential transactions.
Common issues. Sometimes people don't deal properly with tenancies in agreements of purchase and sale. I've seen instances where, so the standard REIA form says that unless there's an indication to the contrary, that the property is being sold without a tenancy. And I've seen instances where the vendors intend to foist their tenant on, like they don't have a contractual right to terminate the lease, and they're in a position where they have to foist the tenant onto the purchaser.
Because the Residential Tenancies Act doesn't let you just get a tenant out.
Deal with tenancies properly. Know that if you're going to terminate a tenancy, that you're doing it in accordance with the Residential Tenancies Act. And know that even if you are in compliant with the Residential Tenancies Act, that the tenant may not leave willingly and may make it more difficult for you to close your deal, right? So I see issues with respect to tenancies. I think it's important that people understand what they're doing when they waive a condition and they understand the implications of it. I think a lot of people do not understand that residential real estate in Ontario is, generally speaking, buyer beware, right? And so there are limited required disclosures at common law and under statute. But generally speaking, if there's something very important about the property that you're relying on that needs to be true to make your investment make sense or worthwhile, you have no recourse against the seller, and if that thing turns out to be untrue, unless you put it in the contract. So the rule in Ontario is buyer beware. Sellers have very limited disclosure obligations. Basically, sellers can't fraudulently, sneakily hide defects that would have otherwise been observable without their craftiness. Sellers also have an obligation to disclose issues which render the premises dangerous or uninhabitable. So if there's a major structural issue with the building, or there's a gas leak should be fixed before you're selling the property, but there's maybe mold that's dangerous that runs throughout the property that can't be breathed in, property is not livable. Those are the kinds of things that need to be disclosed. But absent required disclosure, if you're thinking that something is in working order and it turns out not to be in working order, or you're thinking that it's your personal home, you're buying it, and there are going to be no holes in the wall behind where these pictures are that the stager's done. Anything you're relying on, you got to put it in the contract, right? So I would say that. I think that people need to understand a status certificate in the context of condos is somewhat mystical. People don't really understand what it is. And what the lawyer is doing when they're reviewing a status certificate. So they're really not prepared for the call. But basically when you buy, so it's important to have a status certificate review condition. Some people waive it, but it's important to have a status certificate reviewed by a lawyer before you sign a firm deal. Or if you're going to sign a conditional deal, make sure that it's conditional on status certificate review. Because that's going to indicate to you whether there are any issues with the condo corporation or your unit potentially in particular, which could affect the value of the property and which could affect the maintenance fees that you pay. So those are some, those are some common issues that I would say that people get, taken aback. We have a condo and there's no status certificate review.
But they sign firm anyways, yeah.
Yeah, they sign firm anyways. So I would say, generally speaking, good to have a contract. I mean, if you can have a contract reviewed by a lawyer before you sign it, that's always good. Or at least agree with your lawyer before, these are the things that are going to be in there, and then make sure that they're in there when you sign. So I would say that those are some comments.
Even if you're not buying privately, you have a realtor representing you, and lots of realtors are great, but they're not lawyers. They don't deal with these issues in the same way. So if they're very experienced and they've dealt with a lot of condos, yes, they're going to know to put a status certificate condition in, but even then it can slip their mind. But most realtors are going to point you in the right direction with their clauses. They're going to have standard clauses. They don't want to get sued either, but they're also not, legal specialists, and they can definitely make mistakes and miss things. So even if you're being represented with a realtor, they're preparing the agreements for you, they can definitely miss some of the stuff. I don't know how many times I've heard incorrect information about tenancies from realtors, a listing agent who's just like, oh, well, we'll just tell the tenant to leave. Okay, give us vacant possession, put in the contract, we'll see what happens. But, I wouldn't recommend that to a client, that's for sure. And so what are other common issues with deals closing that aren't necessarily, from the contract side, but just common issues that come up when you're closing a residential transaction?
Usually financing. And that's sort of one of the things kind of outside the scope of what I can do to shepherd the transaction along, right? Like when it comes to financing, your lawyer basically waits for your bank to either give documents and say, these are the documents we want the purchaser to sign before we're going to give him the money to close the deal. Or in some cases, the bank or the mortgage broker might reach out and ask for the lawyer's assistance before the documents are provided. But yeah, we're kind of just like, when it comes to financing, which is the major reason why most deals fail. And I think what would you think, Luke? I think that's probably...
No, that makes sense. I mean...
One, right? So unfortunately, the thing that is most likely to jeopardize the deal is also the kind of thing that is not in my wheelhouse to fix or within my scope of my ability to fix.
There's a small amount of time where sellers just kind of decide they change their mind, they refuse to close. That probably happens more on the kind of sellers we deal with, but yeah.
That can happen. It's rare, but it can happen where people don't understand their contractual obligations. And you know what? Hey, like sometimes, even for buyers, like sometimes not closing is the right move, right? Like we're talking about being pragmatic, right? If there's a property that you have a contractual obligation to buy and for some reason you don't like it anymore, the market's changed, your financing situation has changed, you discovered something about the property that you don't like and it's not going to make sense for you anymore. Like sometimes the cost of a mutual release might just be you forfeit your deposit. And maybe it's better to forfeit your deposit than it is to close on a deal that you don't really want to do, right?
Absolutely. So I have a deposit on the property. I put a $10,000, $20,000 deposit on the property. So if I don't want to close anymore, I could just walk from my deposit and I'm fine, right?
Good question. You know the answer to this. Or we have to say who was your real estate professor?
Carter. He was awesome.
Carter, okay. I had Rosen.
Okay, I loved Craig Carter. Yeah.
Okay, so as we both know, Luke, thank you for that question. So that your damages as a purchaser, if you default, are not limited to your deposit. Deposit is, assuming the deposit is within the reasonable range, like 5 to 10%, the loss of the deposit, if the purchaser fails to close on the closing, is table stakes. The deposit will be lost. In addition, the vendor can sue the purchaser for the difference between the deposit and their actual damages. And how do we determine their actual damages? Their actual damages, the vendor's actual damages, are the difference between the contract price and the market value of the property on the date of the breach. So in certain cases, your damages may be limited to your deposit. In other cases, they may not. What it really depends on is what's the market value of the property on the date of the breach. And we can give a couple of examples. So I buy your house for $1 million, okay? I put down a $100,000 deposit. Closing time comes. I can't close. I can't get my financing. The market's done great things in between the date that I agreed to buy your house and the date that I default on the contract. On the date of the default, your house is worth $1.1 million, right? In that context there, you get to keep the deposit as table stakes, right? Any court will order that, generally speaking, assuming there's no like unconscionability or undue influence or something like that, malfeasance, the court will order. So in that case, you are better off in the sense that the property is worth more to you. You can resell it for more than the contract price. So in that case, your damages are just the deposit, the forfeiture of deposit. Let's take another situation. Say that I buy your house for the same $1 million, and on the closing date, between the day I sign the agreement and the day the deal closes, the market's dropped. The market's dropped 20%. The property that I was buying, instead of it being worth $1 million, is now only worth $800,000. So in that context, Yes, it's table stakes. I forfeit the deposit. You get to keep my $100,000. In addition, you get to sue me for the difference between your real damages, which is the $1 million contract price minus the $800,000 market value on the date of the breach. You get to sue me for the difference between the deposit and the $200,000 difference in market value. So in that instance there, I would forfeit my deposit and you would be able to sue me for an additional $100,000.
And you see court cases of this. You do regularly see situations like this, especially at times when the market changes.
Oh, yeah.
You know, there's a big difference. Someone says, oh, you know what, it went down a lot in value. I don't want it anymore. Or I can't get a loan for it anymore. And then they get sued and there's huge damages awarded there pretty regularly. And I would say, and I mean, you obviously know this, but the situations are so specific, right? You could say it's, you know, what's the difference? Let's say if you had bought a property in January of 2022, I don't know, let's say when the market's going up like crazy. Let's say it's, I don't know, December of 2022, but it's closing in March. By the time March rolls around, it's actually worth more at the time you breach and you can't close. So they're great, except they then relist in March and they don't sell it until June. And now they sell it for less than you had initially contracted. You could make an argument either way because in reality, they're trying to mitigate their damages and sell it. And so even though from a legal perspective, it should be the March date, the reality is they then resold it and got less and they were trying to resell it. Right? So, I mean, it's tricky. And this is why, you know, the law is such a gray area. It's imperfect because the facts matter in each case. And yeah,
for sure. Everything turns out the facts, and everything I've said here, there's no legal advice being given out. Seek legal advice from a lawyer with respect to your unique situation.
Yes. Mark is a lawyer, but he's not your lawyer, and none of this is all for entertainment.
Yeah,
not for legal advice. So, speak to your own professionals. I could ask you a million more questions. Stigma, interesting one to discuss, but
I'm having a great time.
I'd love to discuss stigma. Maybe we'll have you back another time because I think that's an interesting one as well. Before I get to our final questions, I did want to ask a little bit about your opinion on kind of partnerships, JVs, shareholder agreements, GPLP structures. Kind of when, since you do, you know, this corporate work, when do you think that applies? So for example, if me and my best friend want to go buy a duplex together, you know, what's the best structure for us to go buy this versus also if me and 3 friends want to go buy a 30-unit apartment building? And how would you see us structuring those from a legal perspective for these kind of partnerships or...
Good question. You have to be careful who you're taking capital from. And if you're taking any passive capital, you have to be cognizant of securities laws. And you have to make sure that you're only taking capital from people who you can actually legally take capital from. And that's very limited. That's accredited investors, which is securities law speak for rich people, right? People who have over a certain amount of assets outside the real estate market or make more than a certain amount of money. You could take money from family and friends. If you're taking outside capital, you really want to make sure that you structure it properly. That's the first, or passive capital. That's the first. That's the first major thing to note. Then, with respect to a corporation versus a GPLP structure versus just taking title personally and running things with a joint venture agreement or a co-ownership agreement, I think that if it's just 2 or 3 people, I think simpler is better. I think that if it's just a handful of people and the bank has no preference or you're buying it in cash, I think that if you can go on title personally and sign a simple, 5 or 10 page co-ownership agreement, I think that's great. I think simpler is better. I think if we can avoid corporations and GPLPs and complicated structures and just leave natural persons on title to the property, again, assuming that you don't have you're not in a business where if you're in a business where you're likely to get sued and you're worried about judgment proofing the asset, I mean, you might want to hold it through a corporation. But then, of course, you have to remember that you own the shares of that corporation, right? So that your creditors might not be able to access the property directly, but in the event of any bankruptcy or anything like that, those shares are fair game, right, as part of your assets. So there's only so much you can judgment proof.
Yes, because liability protection and corporation flows one way, not...
Yes.
Right? So if the corporation owns the property and something happens to that property, the corporation protects you personally. But if you personally get sued or lose elsewhere, then it can come up and they can claim that.
Exactly. I'm still the corporation. So I would say that avoid complicated structure unless absolutely necessary. And then if you're taking outside capital, or passive capital, you will need a an entity which is going to issue shares or units and take that capital on. So I would say the difference between a GPLP or a corporation, I don't think that one structure is inherently better than the other. I think that both of them are like clay, and you can mold them to be what you need to be to suit most needs, right? The one thing with a GPLP is if you have a situation where the bank really wants one individual on the hook, then if you have a GPLP, the GP, the general partner, is on the hook for the liabilities of the partnership. But of course, any bank that wants somebody on the hook, they're not going to want their holding company on the hook. They're going to want them personally on the hook. And there are ways, even if you have a corporation, we can just pick and choose the people, natural person, the guys who are going to sign the personal guarantee. So I don't really have a preference between a GPLP structure or a corporation and having a shareholders agreement. The thing is you really have to think before you go to your lawyer. Don't let the tail wag the dog, and really think about who's contributing what in terms of capital and work, who's taking on what risks, how are the cash flows flowing, and when are the cash flows flowing from the investment to the investors. And when we say cash flows, we don't just mean rental income. We mean are we going to be refinancing this property? And if we refinance this property, who eats first, who eats second, right? So you have to think about contribution in terms of equity, effort, and risk. And you have to think about who takes their capital back when, and the different ways that capital might flow. And there are 3 ways capital can flow when you own real estate, right? Rental income, a sale, or a refinance. So I think as long as if you go to your lawyer and you say, these are all the answers that I have to all these questions, he should be able to figure out, if he's competent in corporate law, he should be able to figure out a structure that allows you to allocate those risks as you instructed him. And he should be able to assist you taking capital from a bank, debt financing, and potentially taking outside equity capital from people who aren't going to be doing much or any work.
Okay. Since you're not a real estate investor directly, I'm going to skip our typical final question, but we'll ask you one question for our listeners who are looking to get a real estate lawyer or a corporate lawyer to work with, and they don't have one yet, and for whatever reason they're not calling you. What questions should they be asking when they first start kind of interviewing a lawyer to work with?
I would ask them if it's not a simple residential real estate transaction, I would ask them if they've done transactions like this before. I would ask them, they want to be a little bit upfront about their fees, right? Are they going to be billing you hourly? Are they going to be billing you a flat fee? If they're going to be billing you a flat fee, what level of communication can you expect with them? You should ask them, what information do you need from me to get this file rolling and off the ground? And you should communicate to them your expectations, what you expect to walk away with from this transaction. And in varying points in the transaction, you should communicate what success looks like to you. Because if you run into roadblocks, your lawyer doesn't really matter what outcome he values. What really matters is what outcome you value. So the lawyer-client relationship has to be communicative. There has to be open flow of dialogue, and be open with your lawyer. I have clients withhold information from me. If you withhold information from your lawyer, that's grounds for your lawyer to walk away. There are very limited cases in which a lawyer can walk away from a file. But one example is if you don't give, if you withhold information from your lawyer, if you lie to your lawyer, be honest with your lawyer, and you should get good service if he's a true professional. But yeah, I would say that those are the things that you need to think about when you start the relationship and as you manage the relationship.
Okay, awesome. All right, Marc. Well, how can people find out more about you? Where can they get in touch with you? How can they find out about your firm?
I think I'm bymarklaw.com. So that's bymarklaw.com. And they should feel free to, send me an email. I'm pretty sure my email is there. You can call my office. There are 2 Marcs here, Marc DiGiovanni and Marc Soscia. I'm Marc Soscia. So feel free to call. Don't call my partner because he he has a very specialized practice where he has sort of a closed client list. But if you want to chat, certainly happy to any friends of Luke or listeners of Luke or friends of mine.
Awesome. Thanks so much, Marc.